Morning, Judge.
Morning. How are you all?
Good morning.
Hey, everybody.
And Judge, you do have a court reporter.
Good to see you, Ms. Rogers.
Good to see you as well.
You're probably on speaker view. You may want to go on. Good morning.
Good morning. Yep. So if anybody wants to see the Brady Bunch version, just click on Gallery View, and then you'll be able to see everybody.
We can all turn our heads like this, like they
Yeah.
do.
Yeah.
Have you all met before? Just wanted to make sure you all know each other.
No introductions need to be made.
I know.
Good to see all of you. What can I do to help today? So I see that you all reached a lot of agreements with the assistance of Judge. There's some background. And then there are some things that you need help with. One of them I understand to be planes. So
Yes, Your Honor. We actually have reached an additional agreement last night
Okay.
with regard to the appointment of an amicus attorney. We've agreed on Katie Lewis.
okay.
We're just waiting on her to run the conflict check and send us her proposed order.
Hey, but that's one thing down.
All right.
So we've got, Aubrey, I think we have, so tell me if I miss anything. We have legal arguments on this confidentiality agreement. Y'all have a motion to strike. There's an argument about, I think, the airplane and the Cowboys tickets as to whether the court can do anything with those. And then from a factual standpoint, there's use of airplanes, use of Cowboys tickets, Brook Hollow. Did I miss anything?
I think that's correct.
Okay.
You have for protective order set as well.
Yeah, I think that my protective order that I filed was sort of subject to this confidentiality agreement. So once we get that in place, then I think the issues in the protective order go away. So I don't really know that I need to go forward on that. So.
Okay, I'm trying to get Miss Cersei's computer to start. That's why we have an echo. Hang on one sec, sorry. Okay, Jenny, can you hear me?
You may have to put her in another room. That's why I had that same problem a couple weeks ago. And it's like, it's just because the computers are close to each other. The joy of Zoom.
Oh no, I'm sorry, Your Honor.
It looks like you may be on two devices too.
Yeah, sometimes that happens. I may show up.
She's trying to log in through her phone because she can't get the camera to turn on her computer. There she is. So just turn your computer off and log off of that, and you can use your phone because I can see you on your phone. Okay, does that help with the echo?
I'm not getting any echo at this point. So
I don't
Okay,
hear
great.
either.
Jenny, say something and see if you can be heard through my audio.
Hi, Jenny Cersei.
Is that good?
if you
Here.
talk, yeah, if you speak up, I'm soft spoken. So if you speak up just a little bit more, I could hear you. So it's fine.
Great.
But sometimes when we're talking, we have a tendency to drop our voice a little bit, but that works really well to only have the audio coming from Ms. Knatzer's
From one source, yeah.
source. Correct. Okay. So let me pull up. In terms of exhibits, do you all have any agreement regarding and like, do you all come in agreements about pre-admitting any exhibits, or where are you on that?
Truthfully,
No.
Your Honor, we haven't spoken about that.
We've been trying to get agreements on all these other things. So, and some of them, I don't know what will be relevant and won't be relevant based upon your ruling on some of these legal issues.
Okay.
So I don't know if
It's
you
prob-
want to do that first, we'll just walk through these legal issues first and then go from there. Is that okay?
Yes, that's fine with me. So you said the first one was, let's go on the record. This is case number 21-06-221. I know who you all are, but would counsel please state your appearances for the record?
Aubrey Knatzer and Abby Gregory, representing mother Jenny Searcy.
Ike Vandeneykel and Jessica Janasek representing Mr. Searcy.
Thank you very much. All right, I'm going to swear the parties in. We're not going to take testimony at the very beginning, but if the attorneys want to ask you questions later, we can do that. Would anyone who's going to testify please raise your right hand? Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Ms. Searcy, I can't hear what you said.
I do.
Thank you. All right, you all may proceed on, let's address the confidentiality argument first.
First, I'd like to invoke the rule, Your Honor.
Okay.
Yeah, and there's one witness. His name is Jeremy Gee. Is that how you say it? Is it Gee or G?
G.
G. Okay.
Mr. G, I'm going to put you in the waiting room. You can do whatever. You don't need to just stare at the computer. If you just stay within earshot so that you know when the attorneys want to talk to you, I'll bring you back in and we'll get your testimony and then you can go about the rest of your day. Okay.
Yes, I do. Thank you.
Thank you for being here. All right, you may proceed.
Your Honor, my motion for confidentiality order is agreed to with the exception of a request from Ms. Janacek to include or add a paragraph with regard to that I think is inappropriate to add to a confidentiality order. It is on her red line attached to her response to my motion for confidentiality order at page 3 of 7. It's just one paragraph. The confidentiality order puts in place duties on the parties with regard to use and production and dissemination or lack thereof of confidentially marked and identified documents. We have no problem with that. Having a confidentiality order has been an issue since June. I've said I have no problem with the confidentiality order, but I can't agree to this paragraph that she wants to add because I believe, A, as I said, it's not appropriate to be added to a confidentiality order. And it is so broad that it contemplates us not being able to communicate with any investor or customer of any entity or business owned by either of the parties. We don't even have our discovery back yet because she won't give the documents to me because she doesn't have a confidentiality order. There could be 100 businesses. There could be thousands of customers. And frankly, I believe it's her burden to show for some reason there's some risk of dissemination outside what we've already agreed to in the confidentiality order with regard to keeping confidential information confidential. What her paragraph does is modify the rules of civil procedure to put the burden on me to have to ask permission before contacting any third parties that may be named in any report that's produced by her or her client. Any list, I can't contact any list of customers that might be in any report or document that's produced and marked confidential. It's just exceedingly broad with no real basis. I have a duty under the rules to give notice anytime I send a third party request to a third party witness or entity or customer or someone who might have information with regard to this family. She has then 10 days after the notice issues to file a motion to quash for protective order, whatever she may need. The burden shouldn't shift to me. I'm agreeing to a litany of onerous tasks with regard to keeping confidential information confidential. I proposed it, in fact, but adding this paragraph is unreasonable, uncalled for, and unnecessary, and puts an undue burden on me and my client with regard to confidential information. So I would ask that the court enter my version, which is Exhibit 20. My motion with my version attached is Exhibit 20 of the confidentiality order, and deny her request for this change.
Thank you very much. Ms. Janicek?
Sure, thank you, Judge. So just to clarify, we did a confidentiality before the discovery was ever sent. We sent a confidentiality order. We could not get an agreement on the language. Ms. Knatzer did a new confidentiality order. So in an attempt to make agreements, we just said, okay, we'll scrap ours, we'll agree to yours, but we want some additional protections, because then the court may need to hear a little testimony about this or not. But there is concern because Ms. Cersei has threatened to contact investors and other people and tell them what she thinks my client did, whatever that is. And so my client is obviously very concerned because his reputation is basically this business. So it's a private, he's the managing partner of a private equity firm. This is not he's behind the computer sending emails. This is a very, very personal business, and his reputation is the reason that they have the income that they have. And so that's hugely concerning. What I tried to do in these paragraphs, and I was more than happy to make changes to anything, but the answer's just been no, we're not including it, is some kind of protection from Ms. Cersei getting the list of the investors. She's going to get thousands and thousands of pages of documents and look through it and just start contacting people because she's mad, which is what she threatened my client that she would do. So my concern was, how do we protect this? Because if she starts doing that, even if she sends a notice under the rules, the problem is that damage is done. So the idea was to add some kind of protection in here. If she's not going to do that, then I don't see what the problem is of simply saying, look, please tell us, get our agreement. If you don't, it's not that you can't do it. It's just you get the court's permission to do it. That's it. And that way, if there has to be some issue, if we need to get a discovery master, whatever we need to do, we can address it by that point, but the damage isn't already done. So that's the purpose of this paragraph. I don't think it's broad. It doesn't restrict Ms. Cersei from doing anything. It just simply further clarifies that if there is confidential information shared within this divorce proceeding, that not only can she not go around and share it, she can't start calling people and contacting them and talking about what she learned. If it's specifically something related to what's in this paragraph, then she would have to turn around and either get our agreement or get a court order. That's all we've requested. So I understand Ms. Knatzer's concern, but the rules already require them to provide us notice of this anyways. And the rules already specifically state that you can modify the rules of civil procedure at any time if the court chooses to do so. So that's just why we're asking for this additional protective paragraph to be included, and it provides zero harm to Ms. Cersei.
May I briefly respond, Your Honor?
Yes.
The paragraph does not say that we don't share confidential documents. It says we can't communicate directly with any third party, including any investor or any customer. Some investors and customers are other parents at their kids' schools or friends of the family. So where do we draw the line? She can't communicate with people that she knows, people that know about Mr. Cersei's acts and omissions that may be relevant to this divorce that have nothing to do with his business, but may have to do with his extramarital affairs, his excessive spending because he's flying friends around on the jet. So to say, it's disingenuous for Ms. Janicek to say that this doesn't harm her or impede her from doing anything. It absolutely does. It's a prior restraint. It's overly broad and burdensome. And again, it flips the duty for me to get permission before talking to someone. And all they have to do is be listed in a report that he produces that his experts provide for him. So to me, it's fraught with peril. It's not appropriate to be in a confidentiality order, and it should be summarily denied.
Thank you. Anything else?
And just to clarify, Your Honor, I did specifically include that this is not so an expert that we retain provides a report and she can't contact anybody. The purpose of this was just simply to say, if we provide this information, you're not going to start calling customers of this business and just start calling him up and trying to talk to him about stuff, not people at the school, but people that have this information, and start sharing information or start bad mouthing my client. That's the problem.
And I don't believe there's any evidence to show the court that that's even a risk. And if that happens, obviously the court can remedy that situation very quickly. There's temporary restraining orders, there's emergency motions heard every day if something like that happens.
And I agree. I have not put it on any evidence. That's why I said I may need to call Mr. Searcy to testify about that if the court feels like it needs that testimony.
Thank you. So I'll consider that. I don't think I need testimony. I think you all did a very good job of expressing your arguments and telling me your legal positions. So I will consider that one. What I'm going to do is, unless it's something really basic, I'm going to consider everything that you all tell me and not just rule in the moment, because sometimes I always think it's better to think about things before just making a ruling. So I'll consider your arguments, and then I'll include that in my ruling. What about the motion to strike?
That's also my motion, Your Honor. We filed this motion on September the 9th in response to their counter petition for divorce, which included all sorts of evidentiary facts that we believe are completely inappropriate in family law pleading. In that they provide details that are unnecessary pursuant to the 6.402 of the Family Code, which just says that a petition in a suit for dissolution of marriage is sufficient without the necessity of specifying the underlying evidentiary facts if it alleges the grounds relied on substantially in the language of the statute. For example, Mr. Searcy found it necessary to plead adultery and then include who the adulterous affair was with by name in the pleading. That is nothing other than just a stick in the eye and an overtly threatening pleading, as in we're going to reveal who you've had an adulterous relationship with. I could plead multiple names in my pleading for adultery against Mr. Searcy. I have not done that because I don't think it's appropriate. The Family Code says you plead for adultery. The underlying facts, clearly that have to be determined by a judge or a jury or whoever's going to determine them, the fact finder, are elicited through discovery, testimony, and put on as evidence. In fact, if I can share my screen, Your Honor, do I have the ability to do that?
Yes, you both do.
Okay. Even Mr. Vanden Eyck and Catherine Murphy have published in the Texas Practice Guide for Family Law 3.105. All allegations of evidentiary fact contained in the pleadings will be stricken on the motion of any party or on the court's own motion. With regard to 6.402 B and C. Again, I believe this is just an attempt by Mr. Searcy to try to shift blame and publicly utilize his pleadings to embarrass and call into question the character of my client, the veracity of her abilities as a mother, make accusations about family violence without just pleading that family violence has occurred like you should under the statute and that it's likely to occur again. Interesting to note, we've entered into a mediated settlement agreement 3 days ago, that gives my client primary possession of the children, exclusive use of the house, and Mr. Searcy substandard possession with the kids. Gives them all joint rights, they're joint managing conservators. So these evidentiary facts that they have pled, which are clear in my motion, and because according to, again, Mr. Vanden Eyck's case, I can't pronounce it, I'm sure he can, Shrivastava, before the Court of Appeals, talks about part of the reason for 6.402 being in play in the Family Code is because you want to keep people's private facts about their life private. Their retort to that is, well, it's a sealed case, so there's no risk of it being public. Well, here we are on YouTube having this hearing, which is why I'm going to ask that, because I know that the court can read and probably already has read the motion in response, for you to essentially take this issue on submission with legal argument so you can read the pleading and determine what evidentiary facts should be struck. They are detailed in my motion by page and paragraph and quoted, which would make it very easy for the court to make a ruling on each position or each issue. Finally, in the marriage of Richards is another case citing rules 45 and 47, stating that pleadings shall consist of a statement in plain, concise language of the plaintiff's cause of action or the defendant's grounds for defense. That an allegation be evidentiary or be of legal conclusion shall not be grounds for objection when fair notice to the opponent is given by allegations as a whole. We're entitled to fair notice. That's how you're supposed to plead, fair notice without pleading the underlying facts. And the case law supports the court having the ability to strike pleadings even on their own motion for evidentiary facts, much less when they've been so egregiously pled as they have been by Mr. Searcy, for me to actually point out to you what I think should be struck because it's offensive, it violates the family code, and it's not for anything other than prejudice. And its prejudicial component far outweighs any probative worthwhileness in the pleading. They can plead adultery, they can plead family violence, they can plead fraud, they can plead whatever they want in terms of a cause of action, but they don't get to put in the pleading all the underlying facts that underlie their claim. To do so is improper under the rules and improper under the family code. So I'd ask that you grant my motion in total after reviewing the pleadings that have been submitted, including Ms. Janacek's response.
Okay. What is your response?
You're muted.
Sorry.
Jessica.
Sorry, I was trying to unmute. All right. So I don't want to go through each and all of these because there's three sort of tranches of these that they've objected to, but I do think I have to address them a little bit. So I'm going to try to address them a little bit broadly. The first thing to point out, though, is 6.402 talks about evidentiary facts, doesn't talk about facts. That also applies to dissolution proceedings. There is an entire other section of the family code that has to do with SAPSR cases. When it has to do with kid cases, there are tons of sections that say you've got to include affidavits, you've got to include facts, you've got to point out to the court allegations about what's in the best interest, what's necessary for the safety, wealth, and health and welfare of the children, if the children are in imminent harm, all of those types of things. The reason that we've got Miss Searcy's boyfriend's name in there, and the reason that there's also some allegations of family violence and concerns for Miss Searcy's mental health are not because, well, all of the children issues are resolved on temporary. We have an amicus attorney because they're temporarily resolved, but that mediated settlement agreement also says we're going to resolve this, we're going to get the amicus in place, and then we can all come back here before December. It wasn't just we've agreed for her to be primary and that's the end of it. So I want to point out that very significant distinction. The other thing that I would point out is that we absolutely have to put in some specificity about some of these allegations because there's also requests for multiple injunctions in there related to the children, related to paramours around the children, related to Miss Searcy's behavior around the children. And so we have to include some non-evidentiary facts. These are not evidentiary facts. Evidentiary facts under 6.402 have to do with the ultimate conclusion of the case. These are non-evidentiary, but they're also necessary to put the other side on notice of what the issues are. We have agreed to multiple injunctions at this place, at this point. So I want to point out that some of the injunctions that we've pled for, we've already agreed to in the settlement agreement for temporary orders. So we had to put them on notice with regards to some of these injunctions. And we don't want to have such a situation where Ms. Searcy says, as an example, well, I know I agreed to all of these no paramour injunctions, but this person is not a paramour. That's why that's in there, to make sure we put them on notice that this is a concern. The last thing I'd like to point out is there is a section where we've told the court that there are some documents for estate planning purposes. And I need to give a little background on this so it makes sense for the court. For years, these parties have done what most people do that have a lot of assets. They have done estate planning. They have estate planning attorneys. And that is now at issue because Ms. Cersei has filed 2 motions for summary judgment, trying to attack the validity of some of the estate planning documents. Now, I'm not going to get into the weeds on all of that because that's not set here today. But part of what we have to do in our pleadings and our counter petition for divorce is identify to the court that there are estate planning documents that change the characterization of some of these assets that are presumptively valid. Because if I don't want to get into a situation where we've repudiated these documents or that we've breached these documents because we haven't asserted that we want these documents to be validated by the court because they're already presumptively valid. We filed our counter petition after Ms. Cersei filed 2 different summary judgment motions attacking my client's credibility, alleging fraud, putting all kinds of bad facts that Ms. Knatzer doesn't want in the file, all of this in the file about my client and all of these allegations and things that she thought that he did, okay? I had to put in my counter petition some, again, non-evidentiary facts, basically refuting those and then further refuting those in the responses to the summary judgments that were filed. So I think it's wholly inappropriate that Ms. Cersei can file summary judgment motions that have all of these facts attacking the credibility of my client, accusing him of fraud and all of these other things. And then we can't point out to the court, Judge, there are these documents that are presumptively valid, and it is intellectually dishonest for Ms. Cersei to be attacking some of these documents and not other ones that benefit her. And so that is what those sections specifically state. It would be inappropriate and essentially taking out our affirmative defenses for those specific facts to be struck just because Ms. Cersei doesn't like what my client says about her. So I would simply ask the court to find these are non-evidentiary facts. Not all facts from pleadings get struck. If they did, then you would never have any statutes about best interest or safety and welfare or imminent harm of the children. And you would never have any cases about making sure that pleadings specifically put the other side on notice of the issues. And so I would just in whole ask that the court deny Ms. Knatzer's motion.
Okay. Is there anything else you want me to know on that?
Brief response, Your Honor. Ms. Janacek is flawed in her argument in stating that the documents at issue with regard to the quote estate planning issues and documents are presumptively valid. Included in those documents are a trust agreement and a gift deed. Everyone knows it is the recipient of the gift that must prove the factors of the gift. So a gift deed is not presumptively valid just because it exists. Neither is a trust agreement that fails to state what property is owned by the trust. So with regard to the facts pled regarding the estate planning documents, the Richards case, actually, I'm going to share my screen one more time, goes into what is an evidentiary fact issue, and what's the difference between that and an ultimate fact issue. And the court there said an ultimate fact issue is one that is essential to the right of action. Such an issue seeks a fact that would have a direct effect upon the judgment. In contrast, an evidentiary issue is one that the jury may consider in deciding the controlling issue, but is not a controlling issue itself. Whether these documents, if they're enforced or not, have any bearing on whether certain assets are in trust for the parties or their children is not an ultimate issue. Whether they think she's a liar and a cheat or misleading the court is not a fact with regard to an ultimate issue. It's an evidentiary fact they can prove at trial and they're entitled to do discovery on, but that is inappropriate to be in a pleading. And that's all I have on that issue.
Okay.
And I would, the only thing I would say to that is that case has nothing to do with 6.402 of the Texas Family Code. But the other thing I would point out is there's also a partition agreement, and that partition agreement is presumptively valid. And I would disagree with the way that Ms. Knatzer talked about these documents and their presumptive validity. But again, I don't want to get into the weeds on it because it's not in front of the court. Those are summary judgments that Judge Brown will hear at some point later this month. And so again, I just asked the court to deny the request to strike those sections of our pleadings and have us replead.
Okay. Thank you both. What are the issues regarding the airplane or airplanes.
Your Honor, one other housekeeping issue on a motion filed by Ms. Janacek. The motion for protective order, are you withdrawing that on the record, Ms. Janacek?
I am not withdrawing that motion. I am just simply not going forward with a hearing on that motion today. So that motion, I filed a protective order motion. That protective order motion essentially required, when I filed that, I didn't have to respond to discovery, but we did go ahead and respond to discovery. But I simply don't believe I need a hearing on that motion today because that motion, almost all of it was subject to the court making a confidentiality order. And so once the court makes a confidentiality order, then that order then allows us to produce documents because they will then be under the confidentiality agreement or the confidentiality order, however we're going to do it.
All right, so use of the three things I have next are use of airplanes, use of cowboy tickets, use of Brook Hollow Country Club. So let's just go in that order. What is the issue regarding airplanes?
So, Your Honor, we have a mediated settlement agreement that is my exhibit 23. And I guess, Ms. Churchill, you can go ahead and display that. Is that okay, Jessica?
Yeah. And I stipulate and agree that those are the three things that we agreed to address today.
Yes. And so, Your Honor, the parties have two airplanes that both of them have historically used for both personal and business purposes. We agreed in the mediated settlement agreement that you, on page 4 of Exhibit A, on September 10th at this hearing, would address the temporary use of the two airplanes, the G4 and the Phenom 300 specifically. I then, because we've had these discovery issues and I haven't gotten the documents they don't want me to have without a confidentiality agreement, the first I heard of their argument that somehow the court doesn't have jurisdiction to make orders with regard to use of the airplanes was Wednesday at 7:30 when they produced their exhibits with a requested relief for today. The MSA on the very, very last page, page 7, contains a savings clause and states that the parties make these agreements in good faith and agree that their signatures contained herein shall constitute their signature in any capacity necessary to effectuate the agreements. So the reason that's in that MSA, I put it in there, I insisted it be in there, was because we haven't gotten the discovery we need to even know who owns what. There are tons of entities in this case. I knew there may be a different position about ownership of certain assets based on the negotiations that went on during the mediation, which was a 3-week or so process, that Mr. Searcy may claim, well, an entity owns that. So, too bad. Sorry, Charlie, Ms. Searcy can't have access to certain assets. In fact, that's exactly what they did with their requested relief, and the ink was barely dry on the mediated settlement agreement. That savings clause, I think, does two things. One, it essentially means that Mr. Searcy has effectively signed the mediated settlement agreement as the president of ABC LLC. Whatever entity he controls and owns, he has signed on behalf of, as the savings clause states. The other thing that savings clause says is that they're signing in whatever capacity is necessary to effectuate their agreements. And one of their agreements was for you to decide who gets to use and possess the airplanes when. The history in this case is that after Ms. Searcy filed for divorce, Mr. Searcy begged her not to go through with it, pleaded with her not to go through with it. And when I think he realized she was really going to go through with it, he started removing her from things, including access to be able to book flights on their airplanes, including revoking privileges at their country club, all in violation of the standing order. And all my client really wants is a plan. There are 2 airplanes. He produced leases that he wouldn't produce to me before we signed the mediated settlement agreement, but he had to, I guess, for this hearing, that state these planes are leased to a company. And on the exhibits, they state who has the right to use them. And it includes Miss Cersei on one, but on the other, it only includes Mr. Cersei's company. So give his company the Phenom 300, let him use that for personal and business and whatever he wants, and let her use the one that she's already listed as an authorized traveler on. Then they aren't fighting over access. They aren't fighting over planning trips on top of each other. In fact, the evidence is going to show that Mr. Cersei, 15 minutes before Miss Cersei took off with 2 of her children in one of these planes, canceled her flight. Just canceled it. Kids were crying. She ended up driving them to Oklahoma instead of taking them there in the plane like it was planned. And I understand these are all champagne problems, but when you're trying to run a family and a life and somebody pulls the rug out from under you when you're packed for a trip you've planned for 6 months and cancels your flight with no notice and now says, oh, you don't have jurisdiction to hear this issue because it's owned by an entity. I think the savings clause is very clear. What the other thing that Mr. Cersei agreed to on page 6 of the Exhibit A of the MSA was he agreed to be enjoined from taking any action to prohibit Ms. Cersei from the use and enjoyment of the aircraft or club memberships. So he's already agreed he can't prohibit her use. And then we agreed you'll decide who gets to use what when. So the argument of you don't have jurisdiction or the ability to hear this, I think, is completely annihilated by the verbiage in the MSA. The issue with the country club is simply there's no reason they both can't still enjoy privileges there. He has no superior right to revoke her privileges because they're getting divorced. And she ought to be able to go just like she always has, and he can go just like he always has, and hopefully they can act like adults and not run into each other. And then finally on the Cowboy Suite, they historically pay a friend for a portion of the tickets every year. And our proposal is, hey, whoever's got the kids gets whatever tickets they bought. We don't know what tickets they bought because I can't get my discovery because they didn't have a confidentiality order. But whatever tickets they bought, if you've got the kids, you get the tickets and can take them. If you're not going to use them, then you give them to the other party. I mean, it's not unreasonable. It's exactly the same terms that we came to in the MSA with regard to 3 of their vacation homes. You've got the kids, you get to use it. If you're not going to use it, the other party can, because obviously you can't use 3 vacation homes at once. And that way there's some order to the chaos of the back and forth with 3 different children and multiple homes and multiple airplanes. Again, champagne problems, but we need a little order to the chaos. And he has agreed in his capacity as president of TCN Transport or managing member of whatever LLC that you can make that decision. So we're just asking you to make that decision today based on the agreements.
Ms. Janicek?
Sure, thank you. Would you unshare? Thanks. So first of all, I would say, I think there's a misunderstanding of what our argument is. So I will clarify that in a moment, but I would also just point out, just from a technical standpoint, because I can't help it, you can't agree to jurisdiction of something. You can't do that. There's no such thing as that. But we're not making that argument. I just want to clarify. We're not saying the court has no jurisdiction to do anything. That's an incorrect assertion of what we're trying to say. I would also tell the court that it is also incorrect to say that our attitude is, well, the court can't just do anything about the planes. Our requested relief has a specific solution on the planes, all right? And I want to explain because I think there's confusion. These planes are not just owned by the parties, okay? One of the planes is not 100% even owned by the parties, and my client will clarify this and can explain it. But the problem is these planes are both under entities. I understand Ms. Knatzer even filed an exhibit last night at 10:30 showing for the first time that one of the planes didn't pay taxes. And so it's got a tax issue, which can be addressed within 180 days. And it's only been like 3 weeks. So I'm glad that she sent us that. My client didn't realize that. We'll fix that. That's not a problem. But the reality of the situation is that the planes are owned by these entities. And then they have a dry lease operational contract that is for commercial use. I agree that when the parties were happy and together, that they used these planes sometimes for personal use. But if you look at the dry lease, it's with a company called Wing Aviation, and that dry lease gives Wing Aviation exclusive operational use of those airplanes. What Miss Cersei may not seem to understand is that it costs thousands of dollars to fly on these planes. It's not like they own the planes and it's free and they get on a plane and go wherever they want. They have to pay Wing Aviation thousands of dollars an hour to be able to fly on these planes if they're going to fly personally. My client uses these planes, and other employees of his business use these planes to travel around and to do work, which means that the business pays for a lot of their expenses on these planes. It is wholly unreasonable for Miss Cersei to state that she wants complete use of the airplanes for her to fly around personally when she can go to Love Field and get a ticket or Southwest Airlines and fly personally. That's what my client would do. And my client has absolutely no objection to saying if they're going to fly strictly personally around, then they need to go and can fly commercial. There's no reason that they need to spend $6,000 to $7,000 an hour to fly on these planes. However, if they're going to fly the kids, our proposal is, look, if she's got the kids and there's an airplane available that's not being used by the businesses, which again, they have a commercial lease, and Wing Aviation is not part of this litigation. And these businesses that own the planes are not members of this litigation. We're talking about assets that are within entities that have then been signed over to this Wing Aviation aircraft company. If they're going to fly with the kids and the planes are not used, my client's proposal is that's fine. Everyone that has the kids during their possession time, if a plane is not being used for work purposes, can fly around. But there's no reason that Miss Cersei has to have a plane for her to fly around if she wants to go on a girls' trip. Just the same thing that if Mr. Cersei wants to go on a strictly personal vacation, then he needs to use some kind of commercial airline. We completely agree with that. That is our proposal. But these planes are used for commercial use. That is their primary use. That is why there is a lease with Wing Aviation. So our argument, Your Honor, is not the court just doesn't have jurisdiction, can't do anything. Our argument is simply there is already a commercial dry lease that respectfully, I don't believe orders can be put in place that deviate or change from that commercial dry lease for both of these airplanes that put Wing Aviation in control. And on top of that, every time these planes fly around that's for personal use, the parties have to pay for it. It's not free. So I would respectfully request the court look at our proposal. Our proposal is simply if a party has a trip that is a work trip, which the only person that works is Mr. Cersei, then that is going to take precedent, or any other tribe employees, again, which is what this contract covers, have a work trip that takes precedent. And then if Miss Cersei wants to travel somewhere with the children and it's a weekend that she's got them and the plane's not in use, then she can absolutely use the planes. That is our proposal. It was not an attempt to keep Miss Cersei from having access to the planes. The Brook Hollow, I know we were taking this one at a time, but Ms. Konatzer brought up the Brook Hollow. There are, I think, 4 or 5 country clubs, and we've agreed to all but this particular one for the parties to utilize, essentially. We've agreed equal utilization. My client is not trying to take her off of the use of these things. But Brook Hollow is the one where he's the only member. And I stated this before, but Mr. Cersei, again, what he does for a living is very personal. It is him. It is meeting with people. It is meeting with investors. It is making current customers happy. It's trying to make potential investors happy. It's a lot of what he does with this business. And he's very good at doing that. And that's why he brings in the money that pays for all of these things, like private planes. And so my client does not want to go to this one specific golf club that he goes to with his clients. And he's the only one that really uses it. She hasn't used it in almost a year. He doesn't want to go there and have an issue with his spouse there trying to badmouth him. And he will testify to the court that has happened and that is his concern. So all he's asking the court to do is find this one specific golf club membership that he uses for business purposes, that Miss Cersei can't go to that golf club as a spouse when he's the only one that's a member. There's no reason for her to go there if he's using it for business purposes. And the last thing that I would point out is this Cowboys ticket argument. So just to clarify, the parties do not own a suite. They don't have a contract with the Cowboys. They don't have anything like that. What they have is Mr. Cersei on behalf of Tribe he has paid for tickets previously with a friend of his. I think they own a third, some tickets that they paid for the company, not personally. And what our proposal with that is, look, we don't believe that the court can make the guy that owns the suite do anything. We don't believe that the court has the authority to do that. But again, my client is not trying to be difficult. My client's proposal is they use those cowboy suites, just like Brook Hollow, just like the airplanes. Those are things used for business purposes. The documents they've even produced trying to show that he has an interest in tickets, which he's never said he doesn't have or has never paid for tickets, he's never said that, are all him signing on his capacity through the business and also with his business credit card. And so what we'd simply ask the court to do is look at our proposal, which says, if there are tickets available and Miss Cersei has the kids, then absolutely he will give her tickets so she can take the kids to the Cowboys game. But why should her wanting to take the kids or her friends or whoever to the Cowboys game, why should that usurp the use of business purposes for them trying to take a potential investor? That is insane and does not make any sense. And so we would respectfully request the court to look at our proposals. Our proposals are not unreasonable. They are not to try to kick Miss Cersei out of anything. They are simply to try to say, these assets have primarily been used for business purposes. Let's keep them that way. And certainly if Miss Cersei's got the kids and the planes are not being used, she can fly on the planes. If for any reason there's tickets available, she can have the tickets. But her personal usage and her personal want to be equal to my client, when my client's the one working and making the money, is not reasonable and it's not protecting the community estate. So I would simply ask the court to look at our proposals and grant those proposals.
Thank you. Ms. Cancer, do you want to respond to the Brook Hollow part?
Well, Miss Cersei is certainly listed in the Brook Hollow directory as a member. Mr. Cersei, you'll hear evidence that Mr. Cersei does not entertain business clients really much at all. There are SEC rules that are strictly prohibitive of that in his field. Many of his clients are institutions, teacher retirement systems who might invest $100 million in his fund. They are not as frequently, if ever, individuals that he's going to take to Brook Hollow and golf with. He really can't do that under many of the SEC regulations. Same goes with the planes. He rented a $100,000 yacht for a week in the last couple of weeks, took the plane with his girlfriend and wads and wads and wads of cash and extravagant gifts for his girlfriend, and flew on the plane to the yacht in the Bahamas and stayed until his daughter had a tragic accident and he had to fly the plane back to try to get home to be with her for surgery while Miss Cersei was with her where she got injured. That said, this hiding behind, I just use all these things for business purposes, including Brook Hollow, it's a farce. He wants her excluded. He just wants her excluded. He makes to-do lists that are going to be presented as evidence to you about what he's going to exclude her from. Cancel her flights and revoke her privileges at the country club. He's mad. He's rejected. He has told her, the evidence will show, no one will ever love me again, not for my money. Because they married very young and very poor, and they have built this together. 3 wonderful children, a successful business, and he's angry. And so hiding behind the guise of, I use all of this for business purpose is not true. It is, I want you to think I use it for business purposes, and I want to put in the order in my proposal that the business purpose comes first so that I can always say there's a business purpose and she's excluded. It's just a backdoor way to exclude her, which is made evident from the fact that, they have flown personally on these planes as long as they've had them. There is no prohibition on flying for personal use. In fact, family members and friends are listed in the authorized charter addendum to the lease with Wing Aviation. The dry lease is a lease for commercial use. It's for Wing Aviation to lease out the planes when they're not being used by the Cerseys to other people commercially in order not to lose so much money on the planes. And what happens when the Cerseys want to book a flight and it's been booked to someone else, their plane's been rented out to someone else by Wing Aviation, Wing will find them another plane to fly on when they need to fly. It's what happens when Connor and his business partner need to fly at the same time. They find them another plane. This is how they've operated until April 15th, when we file for divorce, and then Connor starts excluding her. And so to say she can't go to the country club because we're afraid she might talk to people, are we going to say she can't go to the grocery store because she might run into a friend in the line and say something about her divorce? I mean, where does it end? He wants to be able to say it's all mine. That's his argument on the estate planning documents. That's his argument here today. It's always his argument. He wants to throw her away because she rejected him. And in doing so, he wants to exclude her from all the trappings of their life that they have enjoyed. So while he does not tap the brakes on spending, I find it comical that Ms. Janacek says he's concerned about preserving the community estate. This man has spent tens of thousands of dollars on his girlfriends. He has taken extravagant trips with them on these planes. He has bought them expensive gifts, including $17,000 Cartier love bracelets. He has rented yachts to take them to. He has spent $150,000 in July on a high-end dating service to find, I guess, some of these girls he can wine and dine on the planes and at the country club. So it is completely disingenuous to say that Mr. Cersei wants to protect the community estate by denying Miss Cersei access to a country club or a cowboy game or an airplane that he flies on constantly. I don't think that he has the ability to revoke her privileges at Brook Hollow, but I know with a court order prohibiting him from doing that. And don't forget the exhibit to the MSA that says he's enjoined from taking any action to prohibit her use and enjoyment of the aircraft or the club memberships. So part of this is already decided by the mediated settlement agreement that neither of them can prohibit the other from use and enjoyment of those things. But beyond that, signing this agreement as president of TRN Transport LLC, he signed this MSA in whatever capacity necessary to effectuate the agreements. So I understand you can't confer jurisdiction by agreement, but his signature is effectively his signature acting as president of a single member LLC and saying, Judge, you tell me what I need to do about the use and enjoyment of these memberships or planes or suite. So they're playing a little fast and loose with the language and the arguments about what he wants and why and what authority he has and what capacity he's signed in. He has subjected himself as an officer of these entities pursuant to the mediated settlement agreement before you and before this court and asked you to make these decisions. So to say that you really can't is, I think, the ultimate bait and switch on the signatures that are on these MSA documents.
Your Honor, may I briefly respond?
Yes.
First, no one said there's no bait and switch. There's no secret. If you look at it, if Ms. Knatzer's argument is, well, the MSA suddenly says that nobody can exclude the other from any of these memberships, then why would we ever agree that you would get to decide what happens with Brook Hollow? That's just trying to say, well, we tricked you. That's not what that says. We specifically agreed that you would get to decide about Brook Hollow. Again, the argument about the airplanes is misplaced. No one is arguing that she can't ever use the airplanes. We haven't even proposed that. Our argument is specifically, there is a commercial lease in place with Wing Aviation. I don't know how anyone gets around that because that isn't a lease, and all of that's also regulated by the FAA. So to sit here and say, well, Miss Cersei should just be allowed to have access to one of the planes and fly around personally. Again, you want to talk about spending? That costs thousands and thousands of dollars for every single hour that plane is used. That's the whole reason. One thing Ms. Knatzer said was correct. It's the whole reason that they have this signed up where other employees of Trive can utilize these planes. I'm not going to sit here and badmouth Miss Cersei and go through her boyfriend and the fact that she's taken her boyfriend to their community or to their properties or any of this other stuff. I'm not going to go into the fact that she's tried to hide and secret the children from my client, which is why he canceled the plane in the first place, because he asked her not to take his children from him, and she did anyways. So I'm not going to go into all of those bad facts because they're not relevant today. We've already made these agreements. The problem is there is an airplane lease. That's one of the problems that we have here is there's a lease. I have somebody who can testify about it. I also have somebody here that's going to testify that when Miss Cersei's plane was canceled, she got mad and called him and basically told him he needed to do a better job in the future with his future job. And she also told him that the wing company would not be doing business with them anymore, which she's not authorized to do, but that's embarrassing and inappropriate. And my client's going to testify that she's threatened all kinds of things because she's angry that she signed a bunch of documents and then filed for divorce before the estate planning was done that essentially took all of these assets and gave it to their children. It's not my clients, it's their children's property that she's trying to claw back. So that is the problem. This is not my client is angry and wants to exclude her. If he was angry and wanted to exclude her, I'd be here today saying she should get nothing. She should be on a complete budget. She needs to go get a job. We're not doing any of that. We have made a lot of very reasonable agreements to try to keep things moving, go to mediation, keep things moving down the road. And Miss Cersei essentially wants to say, I want personal use of the airplanes. I want personal use of these Cowboys tickets. I want personal use of this Brook Hollow Country Club because it's my right to do it. That is not reasonable, Your Honor, and that's not fair and that's not just. And we're simply asking the court to look at our proposals that we've made and make some orders that allow my client to use these airplanes for business purposes, to follow the leases that respectfully, I don't think anybody here can change because Wing Aviation is not a party to this lawsuit, and simply allow my client to use one country club, just one, where he doesn't have to worry that his wife's going to show up and badmouth him, which she has already told him that she's going to do. So that's where we are, Your Honor. I think you probably need to hear some evidence at this point or some testimony, but those are the issues, and that's what we're asking the court to do today.
All right, thank you. So in terms of taking testimony, would you all like to call Mr. G out of order, or do you want to just, you don't have to?
I would like to, so we can let him go on his way. That would be nice.
Ms. Knatzer?
I would prefer, if I may, to put on my evidence in the order I'd like to, which would be to call my client to explain more context before just letting them put their witness on first. It's my motion.
That's fine. I was just checking. It's fine either way. So at this point, we'll switch over to taking testimony. So Ms. Knatzer, you may proceed, and then cross can take place after that. Go ahead.
Thank you. I would call Jenny Cersei. Mr. Could you please, well, she's going to go through my audio.
Okay, I'm just saying she's been sworn in.
Oh, I thought you said she was muted. But then I guess maybe you would be singing that if she was muted. Would you please state your name for the record?
Jenny Cersei.
And are you the petitioner in this divorce case, Ms. Cersei?
I am.
Currently married to Connor Cersei?
Yes.
Your Honor, if we could have him turn his video back on, Mr. Cersei.
One that's going to be participating in the hearing needs to have their video on.
Connor, can you turn your video on? Oops, you were on mute.
I apologize. I just had to use the restroom. I'm back on.
I'm sorry. Go ahead. May I proceed? Okay. You're currently married to Connor Cersei?
Yes.
And he is here on this Zoom hearing as well, correct?
Yes.
You're the mother of 3 children?
Yes.
What are their names?
Will, Brooks, and Ellie.
How old are they?
17, 15, and 14.
Okay. A few days ago, on the 7th of this month, we executed a mediated settlement agreement in this case for temporary orders, correct?
Yes.
And that is Exhibit 23, correct?
Yes.
In that mediated settlement agreement, we agreed to come to court and ask the court to render judgment on it, didn't we?
Yes.
And that's on page 3 of the mediated settlement agreement, correct? I would offer Exhibit 23, which is the MSA.
I don't have any objection to the MSA.
Exhibit 23 is submitted.
Do you believe the agreements you've made in this temporary orders in mediated settlement agreement are in the best interest of your children?
Yes.
Do you also believe the financial terms are fair, just, right, and equitable to you and Connor?
Yes.
Are you asking the court to approve those agreements?
Yes.
We presented a summary of requested relief that was marked as P1 to the court. Do you recall that?
Yes.
And if I asked you about everything on P1, Absent the request for the amicus attorney, which we've subsequently agreed to, would those be your requests of the court today?
Yes.
I would offer P1 as a summary, subject to cross.
I have no objection to P1 as a summary.
Okay, it's a minute as a summary.
Thank you, Your Honor. The 3 issues we have left to deal with today, other than all the issues we settled in the mediated settlement agreement, are the use of airplanes, the use of a country club, and the use of a Cowboys suite, correct?
Right.
Now, you and your husband were able to reach agreements regarding conservatorship of your children, correct? And just for the court reporter, so Emily doesn't yell at me, when I ask you a question, will you make sure to answer audibly so that
Yes.
she can write it down?
Yes.
And try not to talk over anybody so that she doesn't become incapable of writing everything down.
Let me ask a quick question. Ms. Rogers, to that point, are you able to clearly hear the witness? Because it's one thing for us to hear, another thing for you to be able to hear and clearly take it down.
As to now, I've been able to hear her. She is very faint. So maybe if you could just try to speak up a little bit, that would help. But so far, I've been able to hear everything.
Okay.
Okay.
I'm scooting a little closer to her as well.
Yes, I'll speak up.
Would it help if I turned my volume up?
No, because your volume is just going to be.
For me, okay.
Okay.
You and your husband were able to agree on the most important things to you, correct?
Yes.
Okay, so with regard to your position on these 3 issues, can you tell the court generally what your position is?
Yes, I'm sorry that we're here in front of the court today and a bit embarrassed that a judge is having to get involved.
Okay. Can you tell the court what access you had to Wing Aviation prior to filing for divorce?
I had full access. I had direct communication with scheduling. I could talk with the pilots. I had the Wing management app on my phone so I could see which airplanes were going where, when, and I could schedule any of my own flights.
Was there ever any prohibition with regard to your contact with Wing on you or Mr. Searcy taking personal trips on either of the airplanes?
No.
How frequently did you take personal trips on the airplanes?
At least once a month, multiple times a month, sometimes.
And would those be with Connor?
The trips. I also took the kids wherever they needed to go, whenever they needed to go.
Would you fly by yourself on occasion?
Yes.
Would you and he fly together on occasion?
Yes.
Without the kids?
Yes.
For personal trips?
Yes.
Okay. How many planes do you have?
We have 2 that we use for personal use, and then we have others that we lease to the government.
Okay. But those are never flown on by the 2 of you?
No.
And the 2 that are used for personal use are those the G4 and the Phenom 300 that are mentioned in the mediated settlement agreement?
Yes. They
Okay.
are.
And those are the 2 that your husband produced dry leases for on Wednesday evening, correct?
Yes.
I want to go to exhibits P2 and P3. Ms. Churchill, and ask you if those are true and correct copies. Well, let me do it one at a time. Is P2 a true and correct copy of the quote dry lease for commercial operations that Connor, your husband, produced a couple nights ago in this case?
Yes. It's what he produced.
Okay. And do you recognize his signature on that lease throughout on both the schedules and the lease itself?
Yes.
I would offer P2.
I have no objection to P2.
Same questions with regard to P3, except that it is a commercial dry lease. I'm sorry, an exclusive aircraft dry lease for commercial operations labeled P3.
Yes, but he's signed.
They've signed multiple originals at the back.
Oh, I bet. Okay, so I'm seeing
His signature on the very last page.
I see his signature on Schedule C, but I don't see it. Oh, I've got 2 versions of Schedule C.
There you go.
Okay.
Offer P3.
No objection to P3.
Okay, so let's take P3 first. You see that Schedule C for the Phenom 300. You see that?
Uh-huh.
And Schedule C designates a charter customer list. You see that?
Yes.
And who is the only designee on the charter customer list for the Phenom 300?
Tribe Capital Management LLC.
Okay. And then on P2, same question for the G4 airplane. Who is listed and designated as on the charter customer list on the G4 lease?
Tribe Capital Management LLC, Connor Cersei and family, Chris Zagaro and family.
And who is Chris Zagaro?
Connor's business partner.
Okay. Given the fact that only Tribe is listed for one of the planes, whereas you and your family are listed for the other plane, what is your proposal in that regard?
That potentially it would be easier and simpler if Connor retained access to the Phenom 300, given that he's already listed as a designated charter customer through Tribe Capital LLC. And then because Connor Cersei and family, which is obviously me, is listed on the G4, that I continue using that.
Okay, now back to the MSA and the what I called the savings clause. You and Connor agreed that you were signing that mediated settlement agreement in whatever capacity necessary in order to effectuate your agreements, correct?
Yes.
Your Honor, I'm going to object at this point to relevance, and I'm also going to object that the document speaks for itself.
What's your response?
Well, of course it's relevant. They're saying that these are owned by entities. That's one of their requests and statements in their requested relief. And obviously it's an exhibit. I can read from an exhibit that's been entered into evidence, which is a contract between the parties.
So I'm going to overrule the objection. You may continue.
Thank you. And Connor executed the leases with Wing Aviation in his capacity as president of TCN Transport 4 LLC and TCN Transport 300 LLC, correct?
I see that in the document.
And based on some Secretary of State filings that are exhibits, well, let me take them one at a time. Exhibit 24, which is a certified copy of the Secretary of State filing for TCN Transport 4 LLC that owns the G4. Are you aware of who the sole member is of that LLC?
Yes.
Who is it?
Connor Cersei.
Okay.
I could not hear that.
Yes, I'm aware that the sole member of that LLC is Connor Cersei.
Is that good, Emily? Okay. I'd offer P24.
I have no objection to P24.
Is that admitted?
I'll admit P24.
So to the extent you and he signed the MSA in whatever capacity necessary to effectuate your agreements, is it your position that Mr. Cersei signed the MSA in his capacity as president of TCN Transport 4 LLC?
Yes.
Okay.
I'm going to object that that's asking for a legal conclusion. And also, I don't, again, objection to the relevance to this. We stipulate that these planes are owned by these entities. We stipulate that Mr. Cersei is the managing member of these entities. That's not the issue. And I've stated that several times. The issue is this lease that they have.
Okay. I'll sustain those objections. Ms. Knetzer, you can ask your next question.
Sure. Do you know when your access to the G4 and the Phenom 300 changed?
Yes, around April 19th, 2021.
Okay. And how did you become aware that your access changed?
I went to I went to look at the flight schedules for the G4 and the Phenom 300 to book our summer family plans with the children, Brix's horse shows and other travel. And I couldn't see the G4 through my app anymore. So I could tell I didn't have access.
Okay. And who, based on your knowledge, who had authority to book flights and access the plane schedules through the Wing Aviation site?
I thought Connor and I both did, but apparently only Connor does.
Okay. And has Connor done anything since April of 2021 to prohibit you from flying on either of those aircraft?
Yes.
What has he done?
He canceled the flights that I had booked to take the girls to Oklahoma City and then continue on to North Carolina. And he canceled that flight at 7:45 when we were due to get on the airplane at 8.
I'm going to draw your attention to P8. Is that a true and correct copy of an email you received from Wing scheduling, canceling your flight?
Yes.
I would offer P8.
No objection to P8.
P8 is admitted.
Thank you. I want to now draw your attention to P6. Can you identify P6 as a true and correct copy of a photograph you took of some notes written by your husband?
Yes.
Okay. Have you made any changes or alterations to that photograph?
No,
Does it fairly and accurately depict what it purports to depict?
it does.
I'd offer
Yes.
P6.
I object to relevance. This is about the use of the airplanes. This is not an enforcement hearing, so I don't know what the relevance is.
So, Your Honor, the relevance is that with any catch in the ruling about the use and possession of the airplanes, Mr. Searcy has a pattern of trying to thwart her ability to use both the club memberships and the airplanes. So I think it's absolutely relevant that this is something, a to-do list that Mr. Searcy would write to cancel her flights and remove her access to clubs.
Well, I'll admit it and give it the appropriate weight for you can continue.
Thank you. When did you see that to-do list on P6, approximately?
July 5th.
Okay. When he canceled your flight later in July that you just testified to, how did the girls react?
They were really
Objection relevance. We've already resolved the conservatorship issues.
I believe this goes to a conservatorship issue. I think it goes
How
to
did children react?
Searcy's, right. He canceled their flight too. If given the authority to manage and solely and exclusively use these planes, that's exactly what he's going to continue to do. I think it's absolutely relevant.
So what I hear is the focus of the question is being disruptive. So ma'am, I'm just going to carve the question a little bit. Was it disruptive for you and the children for that to happen? For the flight to be canceled?
Yes, it was.
Well, for you or you and the children.
Yes, for children.
You heard Ms. Janacek argue earlier that the reason Mr. Searcy canceled your flight is because you were keeping the children from him. Did you hear that?
I did hear that.
Can you tell the court briefly what the circumstances were with regard to that weekend?
Sure. Brooks had been grounded, and Brooks was with me in Dallas, and Connor was in Aspen. I had reached out to Connor a few times to find out when he would be returning, because he and I both knew that I had planned to go see my girlfriends in North Carolina on the 29th, leaving at 8 a.m. So I had reached out to him a few days prior and said, when do you plan to be home? I didn't receive a response. So I had planned to take Ellie had planned to stay with my brother and sister-in-law in Oklahoma City that weekend anyway, but I went ahead and planned to take Brooks with me to my brother and sister-in-law's house because she wouldn't have had any supervision at the house in Dallas and she was grounded.
Okay. In fact, what did you do after you left Ellie in Oklahoma?
After I left Ellie in Oklahoma, I drove back to Dallas and stayed with Brooks until I was sure that Connor had made it back. And then I rebooked my flight to go visit my friends. And once Connor walked into the house and was able to supervise Brooks, I drove to the DFW airport to get on my commercial flight.
Okay. Did you try to rectify the canceled flight with Wing Aviation?
I did.
And were you successful in doing that?
I was not.
Okay. To your knowledge, has your husband used either of the G4 or Phenom 300 airplanes since your filing for divorce?
Yes.
Approximately how many times?
10.
Okay. Do you know where he has flown?
Yes. He has flown to Aspen multiple times. He's flown to the Bahamas. He's flown to Mexico. He's flown to LA, Napa, New York, San Antonio, and Austin.
And to your knowledge, were all of those trips for business?
No.
How do you know that?
Because we had friends that traveled with him to the Bahamas, to Aspen, to Mexico, to Napa and LA, and then he joined friends in Austin.
Okay. I want to draw your attention now to P10 and ask you if that's a true and correct copy of a photograph of an itinerary that you took in July of this year.
Yes.
Okay. There been any changes or alterations to that document?
No.
Does it fairly and accurately depict what it purports to depict?
Yes.
I'd offer P10.
So P10, I would object to relevance. I would also to the use of the airplanes, and I would also object to hearsay, because whatever itinerary was created, it was not created by, we don't even know who it was created by. I assume it was not created by Ms. Cersei, but the fact is it's not relevant what his plane itinerary was on a specific vacation, and it's also hearsay.
Your Honor, with regard to relevance, the itinerary indicates that he's flying his girlfriend on tail number N741VE, one of the private planes, the G4, on a vacation somewhere. Her name is apparently Ashley Borman. And Mr. Cersei's proposal to you is that Ms. Cersei only be able to fly in these planes if she has the children with her. Well, that is not Mr. Cersei's habit or practice. And our whole point is we just want to be treated equally and fairly. We want the same status we had when we filed for divorce and were removed against the violation of the standing order. So it's absolutely relevant to that issue, what Mr. Cersei does on these planes. With regard to hearsay, you know what? I'm not offering it for its truth. I'm offering it for the impact on Ms. Cersei. How about that?
Your Honor, respectfully, the impact of it is its truth. So that's absolutely, she's offering it for the truth. The matter asserted that he was flying around on an airplane. The other thing I would point out of why this is not relevant is because our proposal is absolutely not that he can use these for solely personal reasons. We've never proposed that. Our proposal is that if they're going to use it for personal reasons only, they need to fly commercial, need to fly something else. But it's hearsay, and it's just used for prejudicial value. And on top of that, it was done before we signed this MSA. And the MSA says nobody can fly girlfriends or boyfriends or anybody, anything like that, which Ms. Cersei has done as well. Nobody can do that on these airplanes. So objection relevance, objection hearsay.
Okay, I'll sustain the objection so you can ask your next question.
Did your husband admit to you that he flew with his girlfriend on a trip on the private jet?
Yes, we got in an argument.
Let me just ask you the next question.
Okay.
When you found P10 and took the photo that is P10, was Connor present?
Yes.
Okay, and did an argument ensue?
Yes.
Okay, can you tell the court what argument ensued?
Yes, we got in an argument about me taking the picture of the itinerary with Ashley. It has the tail number on it that they took on vacation together. So
what did Connor do next?
He took the phone from my hand and tried to run it underwater. And when I grabbed the phone back from the sink with the running water, he shoved me.
Okay. Were you able to retrieve the photo off your phone?
Yes.
Okay. Did Mr. Cersei also take a trip to the Bahamas with his girlfriend on the plane?
Your Honor, I'm going to object to relevance. This is not an enforcement hearing.
Your Honor, one of their arguments is that we need to pare down and save money and
It's fine. The objections overruled. Ma'am, you can answer the question.
you can answer.
Yes.
Okay. Did he pack a suitcase at the house before going on the trip?
Yes.
Where did he leave that suitcase?
In his closet.
Okay. Was it open?
Yes.
Did you take photographs of the contents of the suitcase?
Yes.
Draw your attention to P14.
Yes.
What did you find in the suitcase?
A Cartier bag, thousands of dollars, and what looks to be 2 sex toys, a vibrator, and I'm not exactly sure what that on is.
Okay. And you
I'm
took,
sorry, I couldn't hear that. A vibrator and what?
and she's not
And
sure
I'm
what
not sure
else.
what the second sex toy is.
You good, Emily? Okay. And you took a photograph of the suitcase, correct?
Yes.
Is P14 a true and correct copy of that photograph?
Yes.
And does it accurately depict what it purports to depict?
Yes.
Offer P14.
Objection relevance. This is not relevant to anything in this hearing. This is just Miss Cersei's therapeutic way of being mad at my client. It's not relevant.
Your Honor, it's relevant to their issue and their argument about the cost of the airplanes, and she shouldn't be flying personally because of the cost of the airplanes.
He shouldn't fly personally either. We agree. Nobody
He's
should
going
fly
to.
personally.
He's going
On
to
the
because
airplanes.
he's going to because he's going to find a business purpose for every flight he needs to take.
Is there a bank there? Do the parties have a banking relationship?
With-
In the Bahamas,
Well, I don't know. I'm asking, is there a banking
Well,
bunch of cash, right? Is it cash for spending? Is it cash for spending or is it for depositing?
I don't.
my client can explain all of the trips because again, a lot of these trips are almost all of them are with investors or potential investors or other people. That's why he's always done trips and he'll explain that. But again, it's not relevant. What he bought for someone is not relevant today, Your Honor. It's just to try to prejudice the court because Miss Cersei is mad at him. That's all it is.
so Your Honor, Ms. Janacek's argument proves my point. He can go on a trip to the Bahamas with a wad of cash, a gift for his girlfriend, a dildo, and a sex toy, and tell this court that's a business trip. So what's going to happen if you approve their plan is that every trip he takes will be for business. He will continue to be flying his girlfriend around and flying friends around from their kids' high school to all these exotic places, while Miss Cersei is only allowed to use the same aircraft if she's got the kids. That's the impact. He's never going to fly commercial, ever. The guy doesn't fly commercial. He has flown a plane that
Right.
delivered.
I get it. So I'm going to overrule the objection. So if she remembers the question, she can answer it.
Well, I had offered
I'm sorry. That's true.
her
So I'll-
objection.
I'm sorry.
That was a long objection.
So I'll admit that exhibit.
Thank you. Has Connor communicated with you with regard to revoking your privileges at Brook Hollow?
Yes.
Okay, I want to draw your attention to Exhibit 15. Is that a true and correct copy of a text message between you and your husband?
Yes.
Okay, and is he saved as Connor on your phone?
Yes.
And his name appears as CS at the top?
Yes.
Okay, did you screenshot this text from your phone?
Yes.
Have you made any alterations or deletions to it?
No.
All right, I would offer P15.
I have no objection to P15.
Okay, can you read to the
P15.
court? Oh, sorry, Judge. Can you read for the court the verbiage at the bottom of the text, starting with also?
Also, I wanted to give you a heads up that I told Brook Hollow we were getting divorced, so they have revoked your privileges.
Okay. Do you believe you should be prohibited from going to the Brook Hollow Country Club?
No.
Okay. Do you use it that often?
I don't use it that often, but I do take the kids there. We play tennis together there. Will plays a lot of golf. So,
Okay. In your observation in your 20+ year marriage to your husband, does he utilize the membership very often?
no.
How does he usually utilize the membership in your observation?
He started playing golf with Will last year. So he and Will go out and play golf. And then otherwise we laugh about the fact we used to use it for Christmas and Easter.
Okay. Have you ever known your husband to entertain investors there?
No.
Now, we filed for a confidentiality order in June of this year, correct?
Yes.
Okay. And do you recall why we filed for a confidentiality order?
Yes, because Connor said he wouldn't produce any documentation regarding the divorce without one.
Okay. You understand that the one paragraph they want to add to the confidentiality order would prohibit you from contacting third parties who are mentioned in any confidential documents, correct?
Yes.
Okay. And you heard Ms. Janacek testify that the reason Connor needs that provision in there is because he fears that you're going to say bad things about him.
Yes.
Okay. Have you done that historically?
No.
Okay. In fact, what's your position, or do you have an opinion with regard to who has disseminated information regarding this case inappropriately in this divorce?
I think Connor has.
Okay. Can you tell the court how?
Yes. He told our children about the affair. He has told our closest friends that I'm at fault for the divorce and that I'm going crazy. He even sent an email to fellow parents of ours at ESD sharing documents of the case with them.
And is that email in P16?
Yes.
Okay. And that's an email from your husband CCing you to some other third parties, correct?
Yes.
Offer P16.
I'm trying to look at it.
Oh, sure. Sorry.
Okay, no objection.
Submitted.
Who else received this communication from Connor on July 7th, 2021?
Whitney and John Mathis.
And who are they?
They are friends of ours with kids who go to school with us at ESD.
Okay. And do you hold any positions at ESD?
Yes, I'm currently on the board and president of the Parents Association.
Okay. And with regard to this communication to John and Whitney Mathis, it also attached what Connor calls a filing that you did that day in this case, correct?
Yes.
In fact, it wasn't really a filing, was it?
No,
What was it?
it was a letter.
And what was the letter regarding?
It was a what? It was a what? A letter?
It was a letter. Sorry.
Thank you.
Sorry, Emily.
It was a letter to Miss Janacek about serving alcohol to Will and his friends over the 4th of July.
And in the email, he says to the Mathises that, as you know, she's lost touch with reality.
Okay. Yes.
Have you ever sent an email like that to any of y'all's friends, or
No.
have you disparaged your husband to your children?
No.
Regarding your suite at the AT&T Stadium, how have those tickets been handled historically?
That we had half or a third ownership in the suite at AT&T Stadium, and the tickets were distributed according to however many we want.
Okay. Do you have any personal knowledge with regard to how many tickets or what share Connor has bought this year?
For this year, I would assume half.
Okay. Have there been years when you bought all of the tickets?
To specific events, yes.
Okay. And who is it that actually owns the suite?
The contract for the suite is in John Mathis's name, and then we pay him directly.
And,
Or we don't pay him directly. He coordinates the giving out of the tickets. He manages the actual tickets.
okay, and John Mathis is the same one that received the email that's P16.
Yes.
Okay. Refer you to exhibits P26 and P27. And do you recognize your husband's handwriting and credit card and signature on that document?
That's not his handwriting, but that is his credit card. It looks like this was signed by one of his admins on his behalf.
Okay, did he give you this document?
Yes.
Okay. Offer P26.
Sorry, Aubrey, when you said, did the admin gave you her this document?
Did Connor give you
Connor
this
did.
document?
Okay, so her testimony is Connor gave her this document, but that's not his signature.
Yeah. Connor gave me this document, yes.
Okay, I'll allow it and I'll let my client explain that. That's fine.
Okay.
I will allow it too.
No objection. How's that? Sorry.
You're busted, Jessica. You're
I
busted.
know. Wrong terminology.
And then on P27, do you recognize your husband's handwriting at the top of P27?
Yes.
Okay, I would offer P27.
What was P27?
Oh, it's the invoice from 2019 to the Mathises with handwriting from Connor at the top.
Oh, no objection to that.
27 is submitted.
Okay. On P27, Ms. Cersei, you see where Connor wrote paid for 1219 B of A?
Mhm.
Yes.
Yes.
Okay. Was it atypical for him to pay directly for the tickets out of your personal funds?
No.
Okay. And P26 is a form that was filled out for Connor to purchase additional tickets with his suite ticket package, correct?
Yes.
Okay. And with regard to the AT&T Stadium events, what is your proposal?
My proposal is that we treat it the same way that we treat the vacation house. Whoever has the children has access to the suite and then, and those tickets, and if they aren't going to be used with the children, that they be offered to the other party.
Okay, pass witness.
Debbie, would you stop sharing? Right, Your Honor, I'm going to reserve my cross-examination questions for our case in chief.
Okay.
I call Connor.
Go ahead.
Getting a request for a bathroom break from.
Sure.
Is that okay? Thank you.
10:37. So we'll reconvene at like 10 minutes from now. Just say 10:38. I mean, sorry, 10:48.
Sounds good.
Yeah, thank you.
Before we go back on the record, is Ellie?
Yes.
Okay.
Or that's Connor's, though, right? Or is that mine?
Yeah, I think it's Jenny.
Sorry.
I've
You need to stay muted. Yeah. There we go.
Okay, so just some guidance. In terms of questions, the attorneys did a really good job providing me with a lot of information in terms of arguments and also some facts that went along with it. I'm happy to hear from the parties about the factual parts as to why they're asking for it. I mainly need to hear the direct part in terms of what the positions of the parties are. You all are entitled to cross people. I'm not going to stop you from doing it, but I need less cross for today's purposes and more just the direct. So hopefully that guidance helps and may make mediation more successful if you guys don't kill each other.
Thank you, Judge. That does help.
Thank you.
Always better if everyone's alive for mediation.
Okay, Ms. Cancer, you may proceed.
Sure. I'm going to call Mr. Searcy.
Go ahead.
Would you please state your name?
Michael Connor Cersei.
And you were married to Jenny, who just testified?
Correct. We're going through a divorce. By the way, can you hear me?
Yes.
Yes.
Are you married to Jenny Searcy, sir?
We're going through a divorce proceeding. Yes.
Okay, I'm going to object to non-responsive. Are you married or not?
Yes, we're still married. Correct.
Okay. And you are familiar with Exhibit 23, the mediated settlement agreement, correct?
Correct.
And you signed that document a couple of days ago, correct?
I did. Yes.
Okay. You have recently taken trips to the Bahamas, correct?
Correct.
And Mexico, correct?
Correct.
And Napa, correct?
Correct.
And Wichita Falls for your son's football game, correct?
Correct.
You've flown back and forth to Aspen to your home there this summer, last summer.
Correct. Yes.
Is it your position that all of those trips were business trips?
Well, those weren't all the trips I took, but the ones that you mentioned, all but one of them was personal.
Okay. And which one was not personal?
A trip to Aspen. I ultimately stayed there personally, but there was also an investor with me.
Okay. Do you expense the private plane costs with your girlfriend to the IRS through Tribe?
If it's personal, we allocate it personally, so I wouldn't be expensing it through Tribe.
Okay. Are there any trips you've been on with any of your paramours that you have expensed to your company?
No.
So when your lawyer said, with regard to the trip to the Bahamas, that you take investors and oftentimes that's a business expense, that was not accurate.
My recollection is we didn't say it was a business expense. If it's a personal expense, I expense it. We pay for it personally. If it's used solely for business, then we expense it. That's the IRS guidelines.
Okay. So when she said in the context of that Bahamas trip, she was incorrect that that was also a trip where you entertained investors.
I don't
Object.
say.
Okay, go ahead. Go ahead.
I'm sorry, I just don't recollect her saying that.
Okay. You also understand, sir, that on the last page of the mediated settlement agreement that you agreed the agreements contained therein in any capacity necessary to effectuate those agreements, correct?
Did I read that? Is that what you're asking? Sorry.
That was your agreement, correct?
Yes, that's part of the agreement.
Okay. And you also agreed in the MSA that you would take no action to prohibit Jenny's use of your aircraft or club memberships, correct?
Based on what
Your Honor, the document speaks for itself.
That's okay. We can put it up on the screen if he doesn't remember.
You can answer the question if you remember.
I do recall that being in the agreement. My expectation was that would be resolved today.
Okay, thank you. You may ask your next question.
You are the president of TCN Transport 4, correct? LLC.
Correct.
And that's the entity that owns the G4 airplane?
Correct.
And that's a single member LLC, correct?
Correct, yes.
And just so the judge knows, you are a lawyer by education and training, correct?
No.
Okay. You have an MBA from Harvard.
Correct.
Okay. And you have a degree from Vanderbilt, correct?
Correct.
You also signed the leases that are exhibits 2 and 3 with Wing Aviation. Do you recall that?
Yes.
And you signed those in your capacity as president of both TCN Transport 4 LLC and TCN Transport 300 LLC, correct?
I believe it's called TCN Transport 3. Could be wrong, but I did sign those in my capacity as president. Yes. Correct.
Okay. You have authority to, for lack of a better term, call the shots with what happens with both the G4 and the Phenom 300, correct, sir?
No, I've got an agreement with Wing that stipulates what I'm able to do and what I'm not able to do.
But you're able to schedule flights without any hindrance, correct?
Yeah, maybe I should take a step back and explain how it works. So we had initially acquired aircraft for Tribe, so because we fly a lot. I've got 50 team members, and we, on average, probably half of them are traveling every single week. And so to burden, and we're traveling to places like Iowa, Grove, Oklahoma, where we have investments and investors. So we bought the plane so that we could get to those places without having to fly somewhere and drive for a full day, have a 2-hour meeting, and then a full day of travel back. And so the purpose of the planes was for work, and that's really the purpose of them now. If they are not being used, then on the 300, myself and my partner Chris can use it personally, and on the 4, if it's not being used for work, then my family can use it personally as well. But the primary purpose of it is for work.
Okay, I'll draw your attention to P4.
Do you mind putting it? Okay.
Yeah, Ms. Churchill is, sorry, there's a little bit of a delay. Do you recall producing to my office in P4 on or about June 7th, 2021, a financial statement dated June 6th of that same year?
Yes, I do.
And is P4 a true and correct copy of that production?
Looks to be yes.
Okay, I'd offer P4.
No objection, Your Honor.
Thank you. P4 is admitted.
So you see under fixed assets on June 6th of 2021, your financial statement, sir, states that both aircraft, the Phenom 300 and the Gulfstream 4, the G4, are personal property?
Correct, yes.
Okay. So it is not true that they are, or at least you didn't disclose to your wife or me at that point that they were not personal property, correct?
I'm not sure I understand the question.
Well, is it your position today that the planes are personal property?
The ultimate ownership of the planes does flow up to us personally, yes.
Of both of the planes?
We own 2/3 of the Phenom 300 and 100% of the G4, yes.
Okay. But that's also through an entity, correct?
Yes, it is.
In fact, Trive Capital Inc. owns the entity that owns the Phenom 300, correct?
I honestly don't recall, no.
So you don't know who owns these airplanes, sir?
I'm not sure which Tribe entity you're referring to that would be above TCN Transport 3 or 4. I just haven't looked at the structure chart, so I just don't know that in detail.
Have you transferred ownership of either of the planes to any entity other than TCN Transport 4 or 300?
No, No,
Okay. You also, I'll draw your attention to P5. Here it comes, sorry. Is P5 a true and correct copy of a balance sheet you produced to your wife on or about September 2nd, 2020?
it looks to be yes.
Okay, I'd offer P5.
No objection, Your Honor.
Thank you. 5's admitted.
And on that spreadsheet or balance sheet as well, if you can blow that up, Ms. Churchill, I don't think anybody can see. Under fixed assets, you list Phenom 300 and Gulfstream as under personal assets as well, correct?
Well, just technically this balance sheet is not all personal, but those two assets would be characterized as personal. This balance sheet includes the CG Cersei Trust and our personal assets.
And your contract with Wing Aviation with regard to the planes, you're the authorized representative on that contract, correct?
When you say that on behalf of TCN Transport?
Correct. But you're the president of TCN Transport, correct?
Yes.
And that's a single member LLC and you're the single member, correct?
Correct.
So when Wing Aviation takes direction from someone about the Phenom 300 and the G4, that would be you, correct?
Correct.
Okay. So you're able to tell them who's allowed to fly, who's not allowed to fly, under what circumstances?
Not completely, no. I mean, obviously I speak on behalf of TCN Transport 3 and 4, and then we have a contract with Wing and they either agree or not agree. But go ahead.
Yep, go ahead.
No, so I was saying I do represent TCN Transport 3 and 4, yes. And I am their relationship for both the planes.
Okay. So if you say someone's not allowed to fly, they have to honor that, correct?
I don't actually know the answer to that. I don't know what the contract says, but I'm the person that normally directs whether people fly or not.
I'm sorry, you cut out for just a second. You are the person who normally directs whether people can fly or not. Is that what you said?
Yes.
Now, your contract with Wing Aviation states that they can lease the planes out to third parties, correct?
Correct.
And they do that to recoup some of the revenue it costs to maintain and service the planes, correct?
Yes, correct.
And so if you call if you call Wing and you try to schedule a flight for any purpose, and the plane of yours that you're wanting to fly on is not available, what happens?
Well, so the way the protocol works is, let's say I call and say, I want to use it for work, then that's automatically accepted. If and by the way, when I say that's anyone on our team, as long as it's authorized by myself and or my partner, Chris. If for the Phenom 300, if Chris or I or a family member were to call up and say, I want to use it personally, then the protocol is they check to make sure that it's not going to be used for work. If it's not, then we can book it personally. And usually we don't have a set rule, but usually it needs to be pretty close to the travel date because we have a lot of work trips that pop up at the last minute. And so usually we have to wait pretty close to the travel date if we're going to use it personally.
And I appreciate all that, but my question really was, what if it's already booked with a third party and you call and need to use your plane? What happens?
Then we
chartered it out to somebody else.
then we can't use it unless times they have a substitute. They'll call the charter customer and say, are you willing to accept a substitute so that they can use it for work or personally. But in but just for clarification, most cases we're not chartering it out except like right before that trip would occur. So for example, if they find a charter customer that would like to pay to use the aircraft tomorrow, then that's easier for them to book.
And you've had to do that on occasion, and so has Jenny, correct?
Use a aircraft not owned that isn't one of the two aircraft, the G4 or the 300?
Correct.
I'm trying to think if yes, probably once or twice in the last couple of years.
Okay. With regard to the Cowboy tickets or AT&T Stadium tickets, suite tickets this year, how much have you paid for tickets for this year?
It's roughly 80. Well, the way that it works is you pay for the suite license and then you have to buy the tickets individually. So I have the suite license payment was roughly $86,000. And for the two preseason games that have occurred, I've had employees and we've had some vendors go with our employees to those games. I don't know the exact amount of that. The credit card that you showed earlier is my Tribe Work credit card. And so it just gets
Object to non-responsive and narrative.
Sustained.
Sir, you're you're a big spender, aren't you?
Objection, Your Honor, to the relevance. I mean, I was hoping this would go along the lines of what you stated to us, since we've not asked a single question. But we're going far afield and trying to try the divorce case. It's not what before the court today, and I'm going to object to relevance. And if we're going to keep going down this road, we're probably going to need a second day for the temporary hearing.
Let me just jump in. I don't have you set all day. Just to help. I have you guys set through noon. I didn't put you all on a clock because you did such a good job of arguing all of these things in terms of argument for the motions. I didn't think that you would need 2 hours for testimony. Ms. Knatzer, what's your response to Mr. Vanden Eyckel's?
My response to relevance is Ms. Janacek's argument that somehow Mr. Searcy wants to save money by putting in place this new plan with regard to the airplanes, that it's certainly relevant that saving money does not seem to be a priority until it comes to denying his wife access to certain memberships, tickets, and airplanes.
Your Honor, it's after 11 o'clock. Our team has not asked a single question, called a single witness. And we have proposals in front of the court that treat the parties equally. And I would hope that I'll have some time left for witnesses.
Yeah, I'm sorry. Just to be fair, I'm not gonna cut you off at noon. That wouldn't be fair. I'm not saying I'm gonna do that. I was just saying, like I'm gonna have to do like a hard stop at 1, but I'm gonna give you equal time.
Thank you, Judge.
You're welcome. So I'll allow him to answer that question, and then Ms. Knatzer, you can move on. So, sir, do you consider yourself to be a big spender?
I'm not sure I know what a big spender is, but we have been blessed. I've been blessed to have financial success in my life. And yes, we do have a meaningful set of assets for sure.
All right, thank you. Do you the 86,000 read about this suite license? Is that for your portion or the entire suite?
That's for my portion.
Which is a third?
It was paid by Tribe, so it's for our portion.
Okay, so is it a third? Is it a third, or is it?
It's rough. This year, it is a third. This year, it's roughly 40% because one of the parties in the suite wanted to sell a few extra seats, so we bought them as a firm.
Okay. Ms. Knatzer.
Sure. Mr. Searcy, can you tell the court why it is not a viable solution for you to have exclusive use of one of the planes and Ms. Searcy to have exclusive use of the other?
Sure. It's again because we primarily use it for work, and so my team here at Tribe expects, and we have an internal agreement that work trips come first, and I live by that like anyone else does on our team, and that's the primary reason why we even have the planes. And so for Jenny and I to split up the planes and just use them personally is just not what they were originally acquired for.
But we went through a list of multiple trips over the summer and you could only tell me one that was for a business purpose, correct?
Well, there are more than that that were for business purposes, but this summer there wasn't as heavy travel, which is normally the case in the summer because people are on vacation.
Objection non-responsive.
Sustained.
Your Honor, he is be responsive to the exact question she asked and the answer she suggested.
It was a new
Well,
question, Mr. McMichael.
It was a restriction, then it stopped me. Sir, I'm just going to ask a clarifying question to try and help. How often are the planes used on weekends?
I don't know, for work, about for work or just in general?
Just for, so I understand what you're saying about work, that the planes are owned for work, and then you all have used them for personal reasons as well when you're able to. On weekends, how often are planes used?
Rarely. It's usually during the week.
Okay, thank you. Ms. Knatzer, you may continue.
Sure. Mr. Searcy, did you revoke or terminate your wife's privileges to attend the Brook Hollow Club during the pendency of this divorce?
Wait, repeat the question.
During the pendency of this divorce case, did you cause the revocation of your wife's privileges at Brook Hollow Club?
I told Brook Hollow that we were going through a divorce, and there was a conversation I had with them where they explained that I was the member and that she didn't necessarily have privileges except as my wife. And so I asked them to close out our charging account.
So is that a yes?
I'm not sure technically she doesn't have privileges right now. She doesn't have a charging account.
Okay. And you thought that was a good idea to revoke her ability to charge at the club?
Well, the reason why we joined the club, I have two
Objection
investments.
non-responsive.
Sustained.
I'm sorry, what was the question again?
You thought that was a good idea, a good plan to revoke her ability to charge at the club?
Yes, it was important to my reputation, yes.
Okay. Now you understand that part of the mediated settlement agreement includes that both you and your wife will spend in accordance with the Dallas County Standing Order. You recall that?
Yes,
Okay. And you're committing to do that, sir?
yes.
I'll pass witness.
Mr. Van Nichol?
Yes, sir. Mr. Searcy, I need to address a number of items that they have asked you questions about and have argued that they are relevant. First, let me start with the overall picture. Your success financially has been in the business called Trive. Is that correct?
Correct.
And that's the business that has approximately 50 team members working for your business?
Correct.
And understanding that you have had, as you said, you've been blessed with great financial success. And I'm only now speaking of financial success. Has your wife worked during the marriage and contributed directly to earning money that resulted in financial success?
No.
So your continued financial success depends on Trive, correct?
Yes, correct.
Now, speaking of personal reputation, which they've asked you about, financially in business, is there a fear that your wife's credibility, reputation, et cetera, if that is tarnished in a business sense, what impact does that have on your community estate and the continued income?
Objection, multifarious objection leading.
Leading objection.
I'll break it down. Sir, there have been questions about reputation. Do you recall that?
Yes.
let's speak about business now. Earning money to build up a community estate. Let's first talk about your wife, who we've established has not worked. Just from a standpoint of the production of income, does her business reputation have any exposure here?
It exposes.
From a business standpoint, income earning.
No, she doesn't have it. She doesn't work.
Okay. Let's shift over to you, sir. How important is it in your business seeking and holding on to investors in very, very high stake funds? How important is it for you to maintain your business reputation?
It's honestly everything. We don't, if I can elaborate, we don't make widgets. We don't make toys.
Objection, non-responsive after it's everything.
Okay. Let's take the non-responsive. Mr. Van Michael, do you want to just ask your next question about it?
Yes. Why is your business reputation, sir, so important to you and your wife and the integrity and protection of your community estate?
Without my reputation, there would be no tribe. And without any tribe, there'd be no income.
Now, how important is it for you to identify places where you need to protect that business reputation during the pendency of this case?
So that I can protect my reputation and thereby protect tribes.
All right. In the last year, has your wife used Brook Hollow?
Not to my knowledge, no.
Do you have investors who are members of Brook Hollow?
I do. I have 2 investors who are members of Brook Hollow.
Has your wife threatened to spread gossip, incorrect, inaccurate gossip about you to the community?
Objection leading, objection assumes facts, not evidence, objection multifarious.
Let me rephrase, Your Honor. Mr. Searcy, would you tell the court whether your wife has made, during this pendency of the divorce, any threats to you regarding your reputation?
She's made threats and she's followed through on them. Yes.
So
Objection
first,
non-responsive after she's made threats.
all right, Your Honor, I'll accept and I'll rephrase.
Okay, go ahead.
Sir, has she made threats first?
Yes.
Has she followed through on them?
Yes.
What danger is there in this case to leaving open the chance that your reputation in the business community is damaged?
I mean, if it's damaged, I would ultimately lose my business.
Now, let's speak of that. Let's say you lose your business. Can't you just go over and put a job application in somewhere and replace this income capacity?
Not this capacity, no.
So you've started a business, correct?
Correct.
You've worked hard in that business, correct?
Correct.
You have been extremely blessed and successful in that business, correct?
Correct.
The requested relief in this case, is it for fun that you've asked for the relief you've asked for?
No.
Is it to protect the community estate?
Yes.
As to Brook Hollow, do you want to continue to use it as a place to maintain and enhance your business reputation?
Yes.
Has your wife ever, during the pendency of this case, with your children and other children present in the house, ever called the police and had them come to the house about something she alleged you did?
Yes.
Is that a big helper for your business reputation?
No.
Was there one scintilla of truth in the allegation she made to the police?
Not at all.
Was she told never by the police, never to do that again?
Objection hearsay. Objection assumes facts, not evidence.
We're not
As to
asking
what anything she was told.
Well, Your Honor, this is one of these that we're not offering for the truth of the matter, just the fact that the statement was made.
And as Ms. Janacek said, the statement is offered for truth because it's offered as the statement is a truth. So objection, hearsay.
I no way, Your Honor, of determining whether the police meant it or could enforce it. The statement, we are wanting to establish that it was made.
I'll,
Your Honor, the statement is hearsay.
for that purpose, it's fine. You can answer the question.
Was she told this was not to happen again?
Yes, the police informed her that.
So just to close the book on Brook Hollow, are you asking the court to let this one asset be yours to use for the protection of your business reputation?
Yes, that's why I didn't object to her using any of the other clubs.
Objection non-responsive after yes.
Sustained.
Oh, for the record, sir, there are other clubs, correct?
Correct.
And you are not asking for her to be excluded from any of them, correct?
No.
What
All
are the other clubs? I keep hearing about them, but I don't know what they are. What are the other clubs, sir?
Maroon Creek Country Club, the Caribou Club, and Park House Club.
Not
What are
to
they?
not to interrupt Judge Teague, but just to help you with less work. Those are in our MSA already, and we've agreed to them.
Where are they located?
Park House is located in Dallas. Maroon Creek Club and Caribou Club are located in Aspen, Colorado.
Thank you.
Are you ready for me to proceed, Your Honor?
Yes, sir.
There were questions asked of you, sir, earlier about whether something was personal property. Clarify for the court what you meant by listing the various assets on your financial statement.
I'm sorry, which one?
Well, speaking specifically of the airplanes, did you originally purchase the airplanes?
Yes.
Did you buy them to fly around on personal trips for you and your wife?
No.
Did you buy them to enhance your business success?
Yes.
Looking back, did it work?
Yes. Did.
Do you want it to continue to work?
Yes, I do.
Now, just to remind you and Your Honor, not solely to remind you, Your Honor, your proposal provides for use of the aircraft for you and her, your wife, as long as you have the children, correct?
Correct. Yes.
And you understand that is an equal application to you and your wife.
Correct. Yes.
Now, clarifying something on that, sir, if you take a business trip, it's got business purposes, but you also, for example, have a girlfriend with you. Does that take away from the fact that it was a business trip to begin with? I'm not talking about deductibility, sir. I'm only asking if you go, let's use the Bahamas, for example. Was there a business purpose for that trip?
Yes, there was.
Did you have an investor there?
I did. Yes.
But you also had personal use in that trip. So does that affect whether or not you're going to have Trive deduct that trip?
Yes, it does.
Okay. But does it erase the fact that you were there for business purposes?
No, it does not.
All right. Now, there was testimony about you trying to grab a phone and shoving your wife. Do you recall that testimony?
I do. Yes.
Is there any truth to that allegation?
No. In fact, it's the exact opposite. She shoved me.
So your wife was the one that shoved you?
Yes.
All right. Now, there was a statement about you taking cash on a trip. Do you recall that?
Yes.
Is there anything unusual about you taking a lot of cash on trips?
No. Can I explain why I do that?
Please.
It's purely for safety purposes. If we get, especially for flying internationally, if I get trapped somewhere, we get trapped somewhere. I've done that with our family forever. Then we have something aside from credit cards to be helpful to get back.
Now, we heard some cross-examination by Ms. Knatzer about you disparaging your wife. Has she ever disparaged you in front of your children?
Yes, she has.
Has she threatened you in front of your children?
She has on multiple occasions.
Now, talking about the cancellation of that one flight, tell the court briefly what plans, if any, you had with your daughter for the weekend she was trying to fly out of the city with her.
So I'd planned a full daddy-daughter weekend with our daughter Brooks, and we had an entire schedule set out, and Jenny intentionally was going to try and take Brooks with her on her trip to preclude me. She had threatened that to preclude me from being able to spend time with Brooks.
Did anyone thank you for canceling that flight?
Yes, Brooks.
There was an email to your friends. Tell the court briefly why it was necessary for you to send that email.
Sure. So for my son's birthday, we invited friends down to our lake house, and John and Whitney Mathis, who were on that email, were chaperoning with me. It was the three of us. And in that letter, we did catch the boys drinking beer. At no time did we serve them anything. Obviously, we caught them. And when Jenny sent that letter over, I sent it on to John and Whitney because they were both really concerned that Jenny was trying to trap them and indicate that they were serving beer to minors too. And
Object to hearsay and narrative at this point.
We'll move on, Your Honor. Has your wife ever made threats specifically about you in business?
Yes, yes.
And in this, the type of business you have, again, you have no physical product that you make. Is that correct?
Correct.
Let's talk about potential. If someone continues to disparage you, what is the magnitude of the potential loss here?
I wouldn't have a business left. If my reputation were tarnished, I wouldn't have a company. Can I explain why that's the case?
Please do.
Is that all right?
Hold on. I understand. I understand. the
Object to narrative. Yeah.
I understand. I mean, it's pretty clear.
Okay, we'll move on then, Your Honor. Let's talk about the cowboy tickets. Has this always been a Tribe expense?
Yes, unless we use it personally and then we pay for it personally, but
Okay.
predominantly been used for Tribe, yes.
And you have made a proposal, again, just to remind everyone, that if not used by employees or business purposes, then if you have the kids, you could use them personally, or if your wife had the kids, she could use them personally, correct?
That's correct. It's exactly why I go to the preseason game, because they were my employees.
I have a clarifying question. In the past, so before any mention of divorce came up, how did you decide what games employees were going to go to or you were going to take clients to versus ones where the family would go to? How did that happen?
It works pretty much like the plane. If they're not all taken by employees or investors or vendors, then we use them personally. And we usually know that pretty well in advance.
Well, how many people get to make that decision other than you and your partner?
It's basically me and my partner.
Okay. Mr. Van Nuckel, you may continue.
All right. What is the flight aware system that is in place regarding the airplanes?
It is a tracking system. When you're on the airplane, it tracks where the plane's flying from, where it's going to.
And do you understand from the statements made in argument that your wife wants equal access to all of the wing software? Is that correct?
Correct.
Is that reasonable for when looking at your business and your business success?
No.
Do you think it's reasonable that your wife be able to track every single trip you are taking for work in real time?
No, I don't. We're getting a divorce.
Has your wife attempted to spy on you during the divorce?
Yes.
Object to relevance, Your Honor.
Oh, Your Honor, I'm responding to the point she made on cross. So that's all I can argue.
I'm not sure what point that is. Object to relevance.
As to relevance, she brought.
All of it.
Okay. Very briefly, sir, tell the court whether or not your wife tried to put cameras in, to utilize cameras to spy on you when you're in Aspen.
Yes, she did.
Your proposal is that the G4 airplane, if not in use, and let's adopt with the brilliant command of the obvious theory, on the weekends especially, that during the weekends, if not used, you would have the use of the plane with the children, correct?
Correct.
And say on the weekends, she would have the other aircraft for use with the children.
I think our proposal is either aircraft if they're not in use, either one of us.
Okay. Okay.
With the children, specifically with the children. Otherwise, if it's for personal, we fly commercial.
All right. And I'll put them up at everything if necessary, Your Honor. Would like to offer respondents one, which is our requested relief.
Any
No.
objection?
The summary, separate across.
Okay, one's amended as a summary.
R2, Your Honor, proposed confidentiality order. I'm going to make sure that's in evidence, so we offer it.
Any objection?
No, I think I actually argued from it earlier. Your Honor.
We'd offer I'm sorry. Is that
Excuse me.
admitted? Thank
Yep.
you. We would offer R3, which is the G4 airplane lease.
I think that's already in as my P2 and 3. Both leases are in.
I
Okay.
did.
No objection.
And
I did admit
you-
them earlier.
Are we admitting respondents 3 as well?
So I admitted them earlier, so we can.
I would like the record to reflect that R3 and R4 are admitted. And again, I'm in no way suggesting that anyone would withdraw an exhibit, but if they did, it wouldn't be in evidence, Your Honor. So I would like those admitted.
Okay, so 2 and 3 are admitted for that purpose.
And R5, the Cowboy Stadium suite invoice, we would offer that.
No objection.
I'll pass
that's
the
it.
witness. I'm sorry.
That's admitted as well.
All right, I will pass the witness, Your Honor.
Okay, Ms. Cancer, any brief additional questions?
Sure. Mr. Searcy, you've called your wife some pretty bad names in your home when your children were present, correct?
Not correct. No.
You've called her a fucking bitch. Is that right?
In front of our kids? No.
While the children were in the house, you called her a fucking bitch, correct?
I do not recall calling her that name.
You've
No.
called her a fucking whore. Is that correct?
In front of our children? No,
While your children were in the house?
no,
You've told her you can't wait for everyone to know what a fucking whore she is, including the children, correct?
no,
You've also planted listening devices in various places in your homes to record your wife's goings on, haven't you, sir?
no.
You understand you're under oath today.
I do, yes.
Okay. And your testimony is that you have not planted listening devices to surreptitiously record your wife in the home?
The only thing I recorded is conversation we had on my iPhone.
Okay.
That we
The
had.
only thing you've recorded were iPhone conversations with your wife?
Yes, yeah, yes.
You haven't recorded any, or have you recorded any conversations between your wife and other people?
The only other thing I recorded was her having phone sex with her affair partner.
Okay, and she didn't know she was being recorded, did she?
I was standing at the door.
Objection non-responsive. You did not tell her she was being recorded, did you?
No, I did not.
Okay. Do you think perhaps taking a girlfriend, wads of cash, a dildo, and sex toys on a vacation where investors are present might tarnish your reputation in business?
I'm not doing anything in front of my investors. No.
Well, you testified earlier that the trip to the Bahamas with the girlfriend was considered a business trip because there was an investor on the trip. Remember that?
Yes.
And your reputation is extremely important to you, especially in this divorce case, correct?
Correct. Yes.
And so do your investors know that you're married while you're traveling with a girlfriend?
I've been abundantly clear since Jenny filed for divorce that I'm moving on. Yes, I'm dating. Everybody knows that.
Okay. And you told her that you would start having sex with everyone you wanted to once she filed for divorce, correct?
I said I would date people.
Okay. You also testified after Mr. Van Den Eyck asked you about protecting the community property estate. That what you're trying to do is protect the community property estate. Do you believe you were protecting the community property estate when you paid $150,000 to a high-end dating service in July?
I did make that payment. Yes.
Do you believe that was protective of the community estate, sir?
But we're still going to spend money. So
Objection non-responsive.
Christine,
You believe that was protective of your community estate?
No.
Do you believe putting a $43,000 down payment on a yacht in the Bahamas was protective of the community estate?
No.
But you did that, correct?
Yes.
When the police came to the Stratford residence, they instructed you to leave, didn't they?
No.
You did leave though, is that right?
Right, because I wanted.
Was it the request of your son, wasn't it, sir?
No, it was because my son.
Objection non-responsive.
Dangerous.
No,
Objection
Your
non-responsive.
Honor, Your Honor, he is being responsive to the question she asked.
Christine, the objection after no. You can ask
Thank you.
your next.
Pass the witness.
Any other questions, Mr. Van Den Eyck?
Just a couple, Your Honor. Has your wife ever used any of your personal assets with her boyfriend during this case?
Yes.
And just to clarify, were you ever told by the police to leave that residence?
No.
Okay, I'll pass the witness, Your Honor.
Nothing further. Your Honor.
I'm sorry, I lost the audio for a second. The last thing I heard was a question about whether or not she used the planes for personal use with a boyfriend. I think that's what it said. And I heard him say yes, and then I didn't hear what happened after that.
I'll ask the last question again, Your Honor.
And the witness is in the room, Your Honor.
Oh, Mr. G is back in here.
I just got re-added, Your Honor. I was sitting here and on hold, but just came up.
Okay, I'll bring you back in just 1 second. Sorry about that. That was my, hit the wrong button. Okay, go ahead.
My last question was, Your Honor, Mr. Searcy, were you ever told by the police to leave your residence?
No.
Pass the witness, Your Honor.
Nothing further, Your Honor.
Thank you. Mr. Van Den Eyck or Ms.
Ms. Janicek, it's going to take over at this point.
Thank you.
Yes.
Okay. Ms.
I would
Janicek.
I would add, Aubrey, you don't have any other witnesses, right? Okay. I have Mr. G. I know this is unconventional, but I'm just going to ask for timing purposes. He's the CEO of Wing Aviation, and that's who they have the contract with. I don't know if the court needs, he was going to testify about that and testify about a conversation that he had with Ms. Searcy. If the court does not feel that they need that for purposes of explanation on the leases of the planes, then I won't waste the court's time.
Ms. Knatzer.
I don't have any objection to letting him, if she doesn't have any questions for him.
I will only if the court feels like you need it, but you've made some comments today that make me believe that you have a good understanding of what's going on. So I don't know that I need to do that.
I mean, I think I do. And I can track pretty easily with the effects of things that either party does in terms of effects of things on businesses or different things in terms of relationships. I'm fairly well versed in some of those things. Certainly not an expert in plane things, but it's less about the plane and more about the use. So I'm going to bring him in and excuse him.
Thank you, Judge.
You're welcome. So, Mr. G, thank you for your patience. This is going to seem mystifying to you, perhaps, but the attorneys have decided they don't need to ask you any questions. So I'm going to go ahead and excuse you at this point. So thank you for being here. I hope you have a good rest of the day.
You're very welcome, sir. And same to you all. Thank you very much.
Thank you.
Thank you, Jeremy.
Take care. Bye-bye.
Okay. Ms. Knatzer, do you have any questions for Mother?
No, I said we had nothing further, Your Honor.
Ms. Janicek?
No, Your Honor. I think you made it clear that you don't need a bunch of cross. So I think you understand the issues.
Thank you. I appreciate that. Okay, so I'm going to consider the testimony from the parties and provide you with the ruling in the next couple days. In terms of the cowboy tickets, is there a way of knowing already if any of the tickets have been designated for, set aside for this client or these things? Have they all been allocated to, like, these are being used, these are not used, and they're available for use? What's the situation, Mr. Searcy?
Not for the rest of the season, no.
Okay, Ms. Searcy, like, I'm going to ask you the same question. Do you know? I think Mr. Searcy probably would have superior knowledge to that, but are you aware of whether or not any of the games have been allocated?
No.
Okay. I think that's the only question I have about that issue. Yep, I don't see any other question in my notes that I was going to ask. I want to thank the attorneys for being professional. I know that sounds like a strange thing to say, but I want to let the parties know that you all have the benefit of having excellent attorneys. And You may know that inherently. You may know that by reputation, but it's very, although this is a costly procedure for sure. I'm sure you are feeling the cost and are aware of the cost. There is a great deal of value that comes from having attorneys that are not going to frivolously spend your money. And so I just want to note that, because I think sometimes people don't have, through no fault of their own, they don't have any reason to have perspective about that. And I appreciate the professionalism of the attorneys, because it makes the proceedings, in my opinion, better for the parties. I'm fine with having a bunch of cross. It's not about me, but the reason I said it, I touched on it, but to elaborate a little bit, you all did an amazing job. The fact that I'm making decisions about planes and Cowboys tickets and country clubs, those are all important things, but the fact that you're able to come to, you came to big agreements about possession and access, and possession and access and use of residence and use of other residences and things like that. That says a lot about you all, and because it's important to me, for your family, that no matter if we spend half a day, we spend half a week, there's no amount of time that I can give you that would ever allow you to say everything that's happened that's important in your lives. So ultimately, Mr. Searcy and Ms. Searcy are in the best position to know what's best for their children. And so I want to commend you all for doing that through the assistance of your attorneys and through the assistance of the mediator. I think you all picked a good mediator too. And this is, I'll stop there, other than to say, in a hearing yesterday, to give you an example, an attorney said, I'm filing a grievance against you, which is fine. It's not really a problem because there was a serious issue. But then they said, I'm coming for you. I swear on my mother's grave. So.
Did you order a copy of the transcript, Your Honor?
Wait, did you make them put any money
In the cup.
in the cup? Did you make them do that?
I did not. I addressed it in another way. So that's a point of levity at the end, just to let you all know, just to reinforce what I'm saying, is family law can be difficult, to put it mildly. I saw that you all agreed to use Dr. Doyle. Again, an excellent decision. Dr. Doyle said last year, all is fair in love and family law. She's an excellent person to help with counseling issues, and she will not steer your family in a bad direction. So again, I want to commend you all. I just share that because it can go the other way really quickly in family law. So again, I want to commend the parties for being able to reach agreements. I'm always happy to help, as is Judge Brown. I'll provide a ruling for you all, and we'll go from there. Okay. I hope everyone
Thank
has
you, Your
a
Honor.
Thank you, Your Honor. We excuse.
Thanks, Judge.